on Honorable Kututu Ablakwa's X page. I think we spoke about that one of our newspaper reviews, maybe yesterday. And he says, "Oh, I've not changed my name, but I'm seeing people say, oh, we have Junior Ablakwa in town. We have low budget,
shade somewhere,
some small shade, and he did it in a very diplomatic shade." That's what happens when you have millennials at the helm of affairs. They don't like to go to websites. They want to go directly to the handle and get the filler there.
You are throwing your shade small inside.
Yes, diplomatic shade.
No, this is also catching small ones somewhere. But Sisters, you have maintained that he still has a long way to go. That's what you're saying.
He has a long way to go. I don't mean, he has a long way.
The way he has started, kind of what?
He has a long way to
go. Talking about long ways, lady and gentlemen, we know that the Chief Justice has responded to the petition against or for her removal. You know that there are 3 petitions against the Chief Justice. The petitions have been submitted to the President. In fact, let's go through the timelines when all of these started. You know that on March 25, 2025, we got notice that the President has referred petitions to the Council of State. And these are petitions that are demanding the removal of the current Chief Justice, Gertrude Tokonu. In fact, for these 3 petitions, we understand that 2 of them came in February and 1 came in March, so last month. And then we got to know that the President has, begun the process or started the process by referring it to the Council of State. 2 days after, the conversation started boiling. Now, there was suit filed challenging the President's referral to the Council of State, and that was on the 27th of March, just 2 days after we got to know that there are petitions against the Chief Justice. Now, on the 27th of March 2025 too, we understand that the Chief Justice, she wrote to the President asking for copies of the petitions against her removal and the argument that people were making. In fact, the Chief Justice writing to the President to get copies, that was after the legal actions or the suits had been filed against the President for going ahead with the process without the, if you like, the knowledge of the Chief Justice. Now the Chief Justice writes to the President asking for copies, and then the President writes to respond to the Chief Justice a day after 27th of March 2025. I'm talking about 28th of March, giving her 10 days to submit her responses to the 3 petitions. The Chief Justice originally, she asked for 7 days. And then the President said, I'll give you 10 days to respond. And that the 10 days of the President elapsed yesterday. So Monday, April 7 was the deadline, or the last of the 10 days the President gave to the Chief Justice. But the thing is, the Chief Justice...
Actually, going back to the timeline, the release from the presidency had said that the presidency had decided way before the suits were filed to allow the Chief Justice respond to the petitions. That was even before we got to know that the Chief Justice had written asking for
that letter that the President was not too happy about.
Yes,
he says it was leaked
to the media even before the President would read it.
10 days the President gave the Chief Justice. The Chief Justice responded in 7. We understand that the response of the Chief Justice to the petition that came on Friday. So the Chief Justice, she stayed with it. I asked for 7. He gave me 10. I don't need the remaining the remaining 3. I don't need it to do anything.
I don't think that is what my lady Chief Justice really signaled.
The interpretation is that
there's no interpretation.
I asked for 7. You're giving me 10. I don't like 10. I like 7. I responded. So this is what it has set the stage for some nice conversations going forward. You know that the injunction application, it will be heard tomorrow.
Tomorrow is the 9th.
Yes. That will be heard tomorrow to hear the 2 cases challenging the suits. There are concerns that these cases went to court because the Chief Justice had not been given the petition, had not been given a chance to respond. Now she has responded. Should we continue? Are the cases, what do people call moot, the mootness of these cases? So we'll be getting into all of that with some legal experts. But these are excerpts from the president's letter after the Chief Justice had written demanding copies of the letter. Sisters, if you could go through that with us.
So it says that His Excellency has received 3 petitions requesting your removal as Chief Justice. 2 are dated 14 February 2025, and the third is dated 17th March 2025. So that's almost a month after.
Right.
On 24th March, His Excellency wrote to the Chairman of the Council of State forwarding the petitions, the 3 petitions. The confidentiality attached to Article 146 proceedings extends to all documents and materials,
right?
Not just the hearing process. And the President said that the Chief Justice would be afforded a full and fair opportunity to be heard, and that the Chief Justice was requested to submit her preliminary response within 10 days of receipt of this particular letter that we are referencing.
So the question that we are asking right now is, where do we go from here, Helen?
I'm hoping that our legal experts can shine the light, because for me it's been quite a technical issue following the proceedings, whether or not we're deviating from the Constitution and so on and so forth. So really, I'm in need of much needed education on really where do we go from here. So good question, and I hope today it's answered.
We'll speak with lawyer Christian Mamhes. In fact, we should raise him right now and get started with the conversation. You know, if you're looking at the dynamics of the case, now the Chief Justice has responded. It means the stage is set like pepe for the determination of what you people call prima facie case. And then if that is done, again, what do we do going forward? Sisters, the dynamics of what we're seeing right now, although we don't know the content of the Chief Justice's response to the petition, but what will go into the determination of the prima facie case?
It's the responses now. And you see, the point is instructive there that the secrecy, if you check the Constitution, it says that the proceedings shall be held in camera.
In camera, exactly.
That is the language that the Constitution
and that is how we can't know the content of the CJ's
response. And that is why her initial response to the presidency, the presidency said it was not excited that it was in the open.
But if the
ideally we shouldn't have known about it.
Let the second one to be open, or they don't do it like that.
No.
Okay.
No.
Christian,
because you see, in this response, my lady will be responding directly to the allegations that have been leveled against her.
The allegations too. We don't know that.
We don't know.
Sisters, hold on for me. Christian Mamhesi, he's joining us. He's a private legal practitioner. Counsel, thank you so much for making time for us this morning. With how the case has traveled so far, from where we have come from and where we have gotten to, and based on where you said, do you think that we are following due process yet? Because the president said in all of this, due process will be followed.
Yes, good morning to the panelists and your viewers alike or listeners alike. Yes, due process has been followed, and it's ongoing. It is folding out by the day, and that's the beauty of rule of law.
There are a few comparisons to make in this case, if you like. Now, if we're comparing this to Charlotte Osei's situation, when she also asked for copies of the petition but was not given to her, this time the copies of the petition has been given to the Chief Justice, and she has responded accordingly. What difference are we seeing in this trajectory?
You see, law as we have it, it goes through evolution. and constitutional provisions having been provided under the Constitution, especially the 1992 Constitution. There could be two cases that could be thriving under the Constitution, or let's say the body collection of laws. Now, if we have two persons, Madam A and Madam B, going through the court system, and Madam A fails to capitalize on every aspect of the law in order to attain the balance of rights in her favor, it does not also mean that Madam B will fail to exploit the law to its fullest limit in order to attain the highest level of balance of rights. What I'm trying to say is that I'm playing an analogy with the parent situation as compared to Charlotte Osei's situation. So this would have happened if the Lady Chief Justice, her leadership, had not been given audience, had not been given, should have challenged the matter constitutionally. Nothing prevented Charlotte Osei from doing so. It was for her legal counsel to have decided what they would have done. So, natural justice, you see, the Constitution, the last time as I was on your platform Saturday with Mr. Okansi, I made a lot of submissions, especially to the point that the Constitution is a living document, and we had learned jurists like Adade, Adeniran, Francois. If you look at the case of Tala Attorney General, Tufu Attorney General, they have all espoused the fundamental principle that when it comes to constitutional interpretation, it deals with the purpose. And in looking at the purpose, we have two aspects. The judge would first look at the subjective purpose and then the objective purpose. The subjective purpose deals with what the framers thought of, the intention of the framers in putting out the Constitution. So you just don't read just a sentence of the provision and you come to a conclusion. And then the second most important part is the objective process. We look at the legal history, the legal values, and the context and the text. And when you combine the objective purpose and the subjective purpose, you will now arrive at a conclusion that will not be unconscionable, that will not be incorrigible, but it will be sound to come to that particular conclusion. And what do you call him? Dr. Dateba in the Frank Chum case elucidated a lot on this particular situation when it had to do with Article 146.
I see. Now, with a response from the CJ and going forward, Counsel, what should happen?
Yeah, so just as Dr. Dateba said, the Council of State, as enjoined under Article 1466, they would have a consultative process. Prima facie will be determined. Yes, in the Dateba judgment, as a lead judgment, he indicated that it was a mistake, an omission on the part of the framers of the Constitution, to have omitted a prima facie statement or provision as far as the second limb of Article 146 is concerned in dealing with the removal of a Chief Justice. But it is very copious when it comes to that of the removal of Superior Court justices. So once that is left out, juries do what we call gap filling, and that is what they will be doing. So the consultative process would happen, and the prima facie case will be determined based on the response that the Chief Justice has provided, and they will go into three aspects or three legal elements of it: whether there is demonstrated ground of incompetence, whether there is demonstrated ground of infirmity of body, mind, such that Chief Justice is unable to do her work, and whether or not
misbehavior.
There's a stated misbehavior. So these are the things. And if it does not meet the threshold, proceedings will not even commence. If they believe that there is an answer for it, then under Article 1468, the matter will be heard in camera, and the determination thereof would come out by way of recommendations for the president to act upon. And it will definitely be constituted by a 5-member committee, of which we all know 2 justices of the Supreme Court, of one who would be the chairperson, and 3 laymen who should not be members of the Council of State, lawyers, or members of Parliament.
I see. Now, this is a case that, based on how it started, we've seen 2 suits that were filed even before the Chief Justice could receive copies of the petition and subsequently respond to these petitions. Now, this suits will be determined, or the injunction applications based on the 2 suits will be determined tomorrow. The question on the minds of many are, now the problem has been solved. The Chief Justice has seen the petition. She has responded to the petitions. What becomes of the injunction applications?
Yes, thank you. Under order 25 of CI 47, injunction applications are timeless applications, and it's a discretionary relief that the court grants in respect of proceedings that the court finds that a party might overreach the other, or where a wrong is being done, that the court believes that the status quo should be maintained, save that the matter is determined, and then the resolution thereof of that particular action could carry on. So that, having said this, it being a timeless application, it's discretionary, and then there are elements, there are 5 main elements that ought to be met. Now, the president having granted this, what becomes of the application is moot, because that which you are seeking to address by way of the interlocutory injunction, it has been resolved. So what are you seeking to injunct? Unless there's a problem with the process that another application would have to address, there is nothing to injunct, because the Chief Justice has even responded, I think.
But, Counsel, before you continue, there's the concern of the possibility of a recurrence as well in next governments, next administrations, future embattled CJs, if a process like this starts as well. There's a concern that what we are facing right now can recur. Hence, the Supreme Court should go ahead and determine this injunction application based on, the facts of the matter. The Chief Justice receiving.
So like I said, the injunction will not fly, but the shift will continue its lateral growth, and most of these cases will find their traces to the Chum case, where Dr. Bar dealt copiously with Article 146. He digested it and went and further suggested that there should the consultative process for constitutional review should make amendments to Article 146 in order to address the procedural lapses there, because the procedures have not been established properly, and as and when it comes up, it becomes very checkered, whether for a particular government, as it may, to adopt its own process, and if that process is not proper, like in Charlotte's case, if the person feels to challenge it, then it becomes another matter. But just as Dr. Ban indicated, this ought to be done in order to put Article 146 as a certain area of law that would not bring such uncertainty as we find it.
Counsel, you're speaking about the discretionary nature of this going forward. But if the court decides to, still go ahead with this, does the applicants, do they have, the option to withdraw? And if they do, what signal is it likely to send?
So I'll not act as the legal advisors for the applicants, but by way of education, I mean, like I said, the suit would take its normal course. I will not go into the merits. It's for the Supreme Court to decide. But with respect to the injunction application, that which they are seeking, the release that they are seeking to, President has given green light to her leadership, and her leadership has responded. And the consultative process is going for a prima facie. Then Article 146 shall determine whether a committee should be formed for Article 146(8) to come in place, that hearing in camera. So all these things are following procedures. They are not a procedure. So as to the substantive suit, I mean, even though I know how the outcome would be, I will not say this on radio because that would be usurping the decision making of the Supreme Court. But generally speaking, this is what it looks like.
Maybe finally from me, Counsel, let's talk about empaneling for tomorrow's judgment. We know that it should ordinarily be the duty or the responsibility of the Chief Justice to select the justices who will, if you like, sit on the case. Now, this is somebody who the case is about. The entire process is revolving around. How should empaneling in a situation like this be like?
Yes. If you look at Lucas, and even again you come to Dr. Ben's judgment, it indicates that the Chief Justice has an administrative duty to empanel the court. And there have been situations where the then Chief Justice was seeking to be taken out, and they challenged he constituting the bench. Now, that particular matter, the judges indicated that the Chief Justice has the bona fide administrative duty. And once you are unable to say that the Chief Justice has acted against law, you cannot cause her to jettison from her duties. She will carry it out according to the letter text of the Constitution.
Now, finally, again, the concerns or the possibility of, with a bench warrant or with a warrant, suspending the Chief Justice while this case travels its full length. How do we merge that or marry that with what we have on our hands right now?
So that is an unlikely situation. And if you look at the wording, that's an unlikely situation. That happens in an extreme situation, and it is for the president to exercise that right in consultation. But I don't readily see that happening. It is a very unlikely tool that would be used where the situation is a very, very dire legal matter. Having mentioned the three grounding elements for the removal of the president, and having come to a conviction that indeed for the procedures to carry on, then that option, as of necessity, must be exercised. That's not the situation we have ourselves in.
See, Counsel, thank you so much for your time with us on the program. We've been speaking with Christian Malmhesi. He is a private legal practitioner, speaking with us on the conversation on the removal of the Chief Justice. The Chief Justice asked for the petitions. The petitions have been given to her. She was given 10 days to respond to the petitions, but originally she asked for 7 days, and she has provided a response to the petitions and also submitted likewise to the Council of State. Now, what is left is for the establishment or otherwise of a prima facie case against the Chief Justice, and then recommendations will be made to the President, and the President will then be bound by the recommendations made by the committee that have been set up to go through all of this. Shak Ibrahim, another private legal practitioner and a law lecturer, who will join us shortly. But Helen, I mean, maybe let me put you on the spot here. If you were
take me off the spot,
let me put you there small. So you know about the bit that the application may be moot going forward, but the court still has the discretion to decide based on the concerns of a recurrence in coming years. If you were an applicant in any of the suits, would you withdraw because what you're looking for has been answered to?
That's a good question. To withdraw because of because we're also not privy to what the answers look like or what the response or rebuttals are. It's very difficult to say because we've talked about how the entire process is shrouded in, is that the right word, secrecy?
Well, confidentiality.
Confidentiality. Yes. I think that sounds, secrecy sounds a bit sinister, isn't it? Confidentiality. It's so difficult to say whether or not, as an applicant, given what has been said, I would be happy with that. It's very dependent on what the response is.
Success, yes, would you withdraw your suit because the substance of what you're looking for right now has been provided, it has been solved?
Whether I withdraw or not, the court would tell me it is it is too late.
No, but I mean,
now you see. No, but you still have to go to court to withdraw. You still have to go through the process. You go to court, they'll call the case, and yes, you then have the opportunity to say, given the development, I respectfully,
I won't do it again.
Ask that the case be withdrawn. That is possible. It is because cases, you go to court on specific reliefs, we call them. Anytime you go into a courtroom, you are asking the court for a specific thing. So you go to say that I want Crosby to be changed into a woman. Hey. You don't say that.
What kind of example is this one?
I'm even surprised.
No, but the courts don't have that power. The court cannot change a man into a woman now.
Maybe you can say,
even though now people are in other jurisdictions are going to court.
These days, if you want, whatever you want to be, you can even be. You can be an aeroplane tomorrow. Quick, let's say you want Crosby to be the presenter on Hot Edition. Maybe that's the relief you're seeking.
Maybe that's the relief you're seeking. But now you don't have to go to court. You just have to walk through.
No, sisters, you did not get any anxiety. You make your point, it's okay.
Or the relief that you're seeking is that Crosby provide lunch each and every weekday.
No, that is a workable relief.
All right.
That is a relief that...
I have song here.
That is a relief that the court can... Anyway, so I was saying, when you go to court, you ask for specific things, and the court cannot give you beyond what you have asked for.
Right.
The court might think that maybe if it's money, you deserve more, but so far as you've asked for this, that's what you get.
Yes.
Or is that one subject to some tweaking?
There are also considerations.
Right.
There's this process in appealing against a conviction, for instance, where you say that the conviction, well, you don't have a problem, but the sentencing you think is harsh.
Okay.
In fact, the court can review your sentence to increase it. Mm-hmm. So you were given 5 years, then you go to the court saying that it is too much. The court, after examining the evidence and everything, can say, but it should have been 10 years.
And you brought yourself.
You brought yourself. So I go back. 5 more for you. So there are those circumstances that the court may go beyond what you are asking for.
Right.
But it cannot give you what you have not asked for. That's the principle.
Okay.
So, and where what you are asking for has already been granted, what do you want again?
Well, so the consent to is that so that in future happenings, it does not be at the discretion of presidents, chief justice. Maybe somebody's feeling magnanimous enough. Okay, don't worry, I'll let you see it. When it is not, it's not mandatory for them to do it. Then it becomes. We go back to this whole back and forth again. So something that there's a need for the court to make a definite determination that maybe. The decisions of the Superior Court, the impacts they have going forward, that going forward in similar cases, the president is by law mandated to let the Chief Justice respond or see the petition, that kind of thing.
Then that may become one of those constitutional exercises that we have seen Martin Pebu undertake. You probably would have heard about the Martin Pebu cases. Martin Pebu and the Attorney General.
The bail conditions,
So it may then become one of those exercises. But then the court will also tell you that it is not proactive. I'm struggling with the choice of word. Your case has to stand on something. The court cannot go making pronouncements when there's nothing happening. Preempting that, some president will come and decide that I want to do this, so we are stopping that future president from doing that or that.
So, that's what Justice Barr in the Ajay case. So he also thought that there was a gap. The element of prima facie case against the Chief Justice herself, that was missing. So maybe they can do that if they want.
No, but the same case talks about processes and procedures that ensure that there are clear processes for doing 1, 2, 3, so that we don't leave it to. But it is not the court that will spell out those processes. So that then will go back to the lawmaker to say that in addition to this, and luckily for us, we are in an ongoing constitutional review process. Okay, so that committee can deal with it. The HK Prempe committee that His Excellency Mahama set up. It's one of the recommendations that they can look into. And the other day I was reading recommendations from the Commission's report 10 years ago, which also said that there has to be an express statement on what to do with such petitions that come for the removal of the Chief Justice. So all of these go back to the amendment of the Constitution to say that let us clearly state this 1, 2, 3 processes, so that there is no doubt in anybody's mind that when we get a petition for the removal of a Chief Justice, these are the steps that we have to follow. If it's for the removal of a justice, these are the steps. If it's for the removal of an electoral commission chairperson or deputy chairs, these are the processes.
Okay.
So all of those are solutions that we can only find in the amendment of the Constitution.
Let's speak with a senior of yours. Let's speak with lawyer Ishaq Ibrahim. He's a private legal practitioner and a law lecturer also.
I am not fit to call him my senior. I beg you.
You call him your what?
Senior counsel. I am not. Okay. I am not even counsel.
Wish you all the best in your journey. Let's speak with Ishaq Ibrahim. He's also a law lecturer. Counsel, thank you so much for making time for us this morning. Let's start from here. From where you sit, how this case has traveled so far to the point that the Chief Justice has now responded in writing to the petitions. And in fact, that response came as far as Friday. You think we're following due process and the right things are being done?
Thank you very much. And good morning to you and good morning to your listeners and then my colleague in the studio. Yes, it's true that there is media report that the Chief Justice has now responded to the petition. And I think that was her original complaint, that she wasn't given the opportunity to respond to it. You remember that we have a live case in court, and people are saying that with this response, actually, the fact that the president has asked her to comment, and her comment, would it stop the case? Many people are of the opinion that it wouldn't stop it, because there's still a live issue as to whether a future president will need to submit to the Chief Justice's comment before. So hopefully, the Supreme Court will try to clarify that particular area. But if that case weren't there, we can see from Article 146 that when this comment is received, in light of the comment, the President is in consultation with the Council of State, will determine whether there is a prima facie case. And if they determine that there is a prima facie case, the number of, if you look at the provisions of the Constitution, especially Article 146(9), says that the President shall, in each case, act in accordance with the recommendation. Article 146(10). Where the petition has been referred to a committee under this article, the President may. So, if, for example, they are determined that there's a prima facie case, then under Article 146(10), the President has the power in subclause 10A to suspend the Chief Justice. So let me just read that provision. In the case of the Chief Justice acting in accordance with the advice of the Council of State, by warrant signed by him, suspend the Chief Justice, which is quite very frightening. If the President has the power to suspend a head of a co-equal branch of government, you can see how flawed our Constitution is. Nevertheless, those powers are given to the President by the Constitution. Then he say in the case of other justices of the Superior Court, so let's leave that aside. So aside the suspension, the Constitution also talk about the President then referring it to a committee. And we are told that that committee would consist of 2 justices of the Supreme Court, and aside that, 3 other people, some people have described as lay people, simple because the President said the members of the judiciary cannot be part again. The Council of State should not be part. And I think lawyers as well. So people have said that the 3 people will be lay people in addition to the 2 justices of the Superior Court who would then make a decision. So they will investigate and have the right comments again from the Chief Justice. In arriving at their decisions. And the Constitution says that whatever recommendations they make, then the President shall implement that recommendation.
Right, Counsel.
So we are in a very frightening period.
Right now, we have a live case on our hand, like you mentioned. The court will make a determination, if it likes, tomorrow, the 9th of April. Now, the consent too about the empaneling process of the court, the responsibility, the administrative duty of the CJ,
the Chief Justice,
who is in the middle of all of this. How do we, if you like, navigate or find our way around it?
I think there was a previous case. I don't remember the case whereby somebody tried to challenge that the Chief Justice should not be part of empaneling of the Justice of the Supreme Court, and it was said that that was an administrative function. But from the wording of Article 146, that gives the President the power to suspend the Chief Justice. Assuming that power was to be activated before the Chief Justice would be empaneled, and if it was activated and the Chief Justice is suspended, one would probably believe that the Chief Justice would then not be in a position to empanel. But if she is not suspended, the law is very clear that it is an administrative function. that she can easily perform.
But, Counsel, we're doing that bearing in mind, for the lack of a better word, her complicity in this whole discussion.
Yeah.
Is that not a matter of concern?
That she will be engaged in paneling the members.
Yes, as she chooses the judges to sit on the case, the injunction applications on the case that surrounds her.
Yes. Yes, I think if you go to the common law, one might argue the rules of natural justice means that she should not be part of deciding matter that will affect her own rights. But as I said, there's a previous case that say it is okay for her to do that because it is an administrative function and not a judicial function. So once it's not a judicial function, the case made it clear that this concern that you are raising does not come in. But as I said, if the president were to suspend her before then she might not be in the position to function because she wouldn't have been actively in that role as the Chief Justice. Somebody else would have made that decision. But as I said, this is a flawed constitution, and unfortunately, we are saddled with those flawed documents, of which we urgently need to reform it.
Well, for now, we don't know whether or not the president will take any decision to suspend her. It looks very unlikely, though, but we cannot tell. But, Counsel, going forward in this matter, we still have up until tomorrow to know what will happen to the applications. The applicants have the option to withdraw this suit. That is something they can do. Is this something they should consider going forward?
It's possible the Supreme Court could consider that. But as we say, the first complaint was the fact that she wasn't given a copy of the petition. I think that side has been settled because the president had given her a copy. But the fact that it's likely to happen in the future, that side has not been settled yet. So the Supreme Court will probably need to look into that aspect. So in that respect, it's possible they would press ahead and make a decision on that particular area. The final aspect is the injunction aspect, because they said that the fact that it wasn't given before this announcement came in, the whole thing was flawed. I'm not sure whether the injunction would prevail. I believe it's very likely that they want to make sure that future such a thing is not repeated. So they'll use the opportunity to clarify that aspect of the law.
I see. Counsel, now what we also understand is that if it's not in the release of the applicants that the possibility of a recurrence or future repetition of something like this, then the court is not should stay away from it because the court is not asking for it, because the applicants are not asking for it.
In that case, if it is not within the release, then it's possible the case will be ended tomorrow. It's possible that they will say that the principal complained that she wasn't given a copy. She has now been given a copy, and that will probably end the matter.
Counsel, thank you so much for your time with us. Ishaq Ibrahim is a law lecturer and a private legal practitioner speaking to us also on these matters.